Good morning. This is Judge Alyssa Perez presiding over the 210th District Court Civil Docket for March 25th, 2026. All matters being heard today are being heard in accordance with all directives regarding remote proceedings. In addition to that, we are streaming all matters live via YouTube for public viewing. Mr. Nanez, where are we starting?
Judge, on page 1, top of the page, calling cause number 2024 DCV 5492, Yolanda Martha Moreno versus Omar Flores et al. Announcements, please.
Good morning, Your Honor. Manny Morgan for plaintiff.
Good morning.
Good morning, Your Honor. Christina McLaughlin for defendant Flores.
So, entry of judgment.
Your Honor, on my end, I think we're just missing one final amount from the hospital so that Ms. McLaughlin can give us the checks. I think we're almost there, so maybe another 30 days, Your Honor.
30? Okay.
Yeah, so we should be good.
Okay, 30 works. We'll do that. Thank you very much.
Thank you, Your Honor.
If you don't have anything else, you're excused. Have a good day. Who's next?
Judge, on page 1, calling cause number 2025 DCV 1997, Eileen Montelongo et al. Versus Antonio Lopez Gonzalez. Announcements, please.
Good morning, Your Honor. Jaco Rivera on behalf of Mr. Mandel for the plaintiffs.
Good morning, Your Honor. William Morales on behalf of the defendants here.
And also entry of judgment. Good morning. How are we doing?
On this one, Your Honor, we're still trying to decide how we're going to separate the allocated 60,000 tendered limits for all of the plaintiffs. So if we could just get 30 days so that we can figure that out and send that to defense so that we can get the checks.
That's fine. Yeah, first entry of judgment, 30 days. Thank you very much. Again,
Thank you, Your
if you
Honor.
don't have anything, you're excused.
And Mr. Mandel will be here for the other hearing at 10.
Okay, sounds good. Thank you.
Thank you.
All right.
Nothing from us, Your Honor. Thank you very much.
Thank you, Mr. Morales. I hope the rest of the day goes like this.
Good man.
Your Honor, I apologize. I was kicked out of the Zoom.
Okay, no worries. Are you? Oh, you missed it. Were you kicked out like in the middle of our hearing?
Yes, Your Honor. I'm sorry for interrupting.
No, no worries. We reset for 30 days. I'm sorry.
Okay.
There's a lot of boxes on my screen.
Okay, I'm sorry, Your Honor.
No, no worries. Thank
Thank
you
you.
for coming back. Bye-bye.
Bye.
All right, who's next?
Page 1, Judge, calling cause number 2023 DCV 1705, Elliot Berg versus Alex Zamora et al. Announcements, please.
Good morning, Your Honor. Patterson W. Kime on behalf of the plaintiff, Elliot Berg.
Dan Gonzalez on behalf of the defendant, Alex Zamora.
So it seems like, yeah, we're here on entry of judgment as well, but I feel like it's quick. Were you guys not just here too long ago, or?
Yeah, Your Honor, I was just speaking with Mr. Stevenson, and actually the reason why I'm substituting for him today is he told me that the judgment was actually entered a few days ago, so he wasn't aware of whether this hearing was going or not.
Okay, so I don't see it. Let me see. Let me check my emails.
I don't have it either.
Yeah. So, I mean, I don't have a problem resetting for 30 days. It's our first setting. You all can look, but let me double check my email and see if I have anything showing that I received anything. Let's see, DCB 705.
And yeah, I could be confused, Your Honor, because like I said, I'm just filling in for Mr. Stevenson, but this should be pretty simple regardless, because I believe this case was already settled, unless Mr. Gonzalez disagrees.
No, yes, we settled it. There was a dispute, or I guess a minor dispute regarding language in the judgment, the entry of judgment.
So
And
I'll give you 30 days to figure it out. Sound good?
Sounds good. Thank you, Your Honor.
Thank you, Your Honor.
Thank you so much. Have a good day.
You too, Your Honor.
Who's next?
Judge, on page 1, calling cause number 2026 DCV 0379. Announcements, please.
Good morning, Your Honor. Jed Unterrecker, Assistant County Attorney on behalf of various county defendants or respondents. And Your Honor, I'm also here with Carl Jones, who's a third-year law student with a bar card, and would ask that he be allowed to present on behalf of the county respondents.
Yes, absolutely. I think Mr. Jones has appeared at least once before that I can remember.
Thank you, Your Honor.
Let me see. Hold on, I think I have the wrong case pulled up. I'm sorry, this is 0379, right? Yes.
Yes, ma'am.
Yes, Your Honor.
Okay. All right. Well, we're set on the expunction, but I don't see, let me pull up the petition. Did you all file a response, Mr. Director?
No, Your Honor, if I may. We did
I'm
not
sorry,
file it.
Mr. Jones, I'm sorry.
No problem at all. Carl Jones, third-year law student on behalf of the county respondents. We did not file an answer, but we are unopposed. If I may, just kind of explain what's happening. This is a pro se case. I spoke to the petitioner yesterday, I sent him an email prior to that, but I spoke to him on the phone yesterday. I let him know that we were unopposed, and as a courtesy, we draft orders and we send them to them. He had PTD in one of the two cases. I'm sure Your Honor's seen that we have special language that is in the order for PTD. So the petitioner was hesitant to agree because he had questions that I did not want to answer as a non-lawyer and because we don't represent him.
Okay,
So
Mr. Jones, let me stop you real quick. Mr. Nunez, is this the individual that you were looking for?
Yes, ma'am. I went outside and looked for James Groom and did not find him.
Okay, yeah, and I don't see anybody in the waiting room. Okay, Mr. Jones, go ahead. I'm sorry.
No problem at all, Your Honor. So this is he's working with Easy Expunctions company out of San Antonio. So he said he was going to contact them and get back to me. I was hoping we'd see him here this morning and perhaps you could assuage some of his concerns. I think it's just a matter of it, committing to a long legal document. He wanted to know what some of his rights were, and I did not feel like I could answer that.
Do we have how are we getting the hearing notice to him? Let me see. I see there was one sent out last week. Okay, so the district clerk is sending him notice. Okay, so I'm going to reset it once, and I'll tell you this. I'm looking at that notice, and I don't think it indicates a Zoom hearing. So I need to, and we'll make sure and let Ms. Nieto know that we're going to do a notice here that is going to be in person. I think that might be easier. How have you been dealing with him? Just over the phone, Mr. Jones?
Yes, Your Honor. I sent an email to him, got no response, and so my habit is to call them the day before. I did say that there was a hearing today, so perhaps he just did not have the number. But yeah, I did speak to him. He did pick up the phone and talk to me. So one on phone, one on email.
Okay, so what we're going to do is we're going to send out a notice from the court we're going to do a Zoom. And I think we have some language in there about them appearing in person, but at least we can include all the login information. So we're going to reset that one. It's going to be a reset for 30 days kind of day. So we're going to reset this one for 30 days.
Thank you, Your Honor, and thank you for allowing me to appear.
Of course. Thank you very much.
Maybe we be excused.
Yes, sir. Yes,
Thank you, Judge.
Thank you.
Thank you. So is 0327, that one was taken care of, Mr. Nunez?
I believe so, Judge.
Yeah, I think that's the one with Rudy Perez. Okay, who's next?
Judge, still on page 1, calling cause number 2024 DCV 2479, Christopher S. Suarez versus Angelica Aro. Announcements, please.
Good morning, Judge. I'm from Mr. Ortiz's office. I'm so sorry, Mr. Ortiz or Mr. Davis were not able to make it today. Mr. Ortiz is an immigration hearing and Mr. Davis had a family emergency according to his staff. But our client did complete the assumption of the loan, so I'm not sure what you would like to set it for. We have a Rule 11 in place as well.
So I'm gonna set it for an entry of judgment in 30 days. Okay.
Okay. Thank you so much, Judge.
Who's next?
Moving to page 2, calling cause number 2024 DCV 1939, Luis Salas et al. Versus Jesus J. Apodaca. Announcements, please.
It's Joshua Biganowski on behalf of the plaintiffs.
Monica Perez on behalf of the defendant.
All right, looks like we're here. Did we have a motion for continuance? Because it's to have the final civil pretrial and a scheduling conference. So let's see. So I think we just need to get our new trial date.
Yes, Judge.
I have a little note here that's telling me that May 21, 2027 is my next available date. If there's any urgency, I'll tell you urgency still means 2027. So if you want something sooner than that, I can look at other dates, but my standard date right now is May 2027. And I
If
don't
we
even
could,
like that date because if I don't have a 2027 calendar in front of me, but I got to think we're going to hit Memorial Day. Pero I don't know if it matters.
if we could push it to June or afterwards, I have my brother-in-law's graduating from college that weekend.
June 4th is the alternate date. See?
That
That
works with
sounds a
me.
lot better.
That's
In
fine,
fact,
Judge.
okay. If we get there, we get there, but at least it's not during graduations and holidays, okay?
Yes,
So
Judge.
June-
And we're currently trying to see if we can resolve this case as well. So that was
course you are.
partially part of the continuance.
Okay, so just get us a new scheduling order, please. You won't have to be here for the entry, and good luck. If you don't have anything else, you're excused.
Thank you, Judge.
Have a
Thank
good
you, Your Honor.
Take care. Who's next?
Judge, still on page 2, calling cause number 2025 DCV 4775, James Hanas versus Evelyn Godinez. Announcements, please. I didn't see anyone from Mr. O'Hara's office, Judge.
Oh, let me see. Oh, this was set for a dismissal. Miss Duran, are you there?
Hi, good morning, Judge. Yes, I'm here.
Oh, it's not dismissed. Let me see. There's an order granting a dismissal dated March 3rd, no? Is that just as to, that's just as to one party? Gotcha. And I remember the attorney, he's not here. Can we give him a call?
Yes, ma'am.
Because it wasn't, I don't believe it was, let me look something up.
Hi, this is a 210 District Court. I'm calling because
Mr.
Mr. O'Hara
Nunez,
is
you're
supposed
not
to be in court right
muted.
now for James.
Okay. All right. We'll see if someone appears and then, if not, we'll set it for a dismissal in 30 days. All right. Who is here on 4936? Mr. Grambling? And that is that Mr. Mundell?
Yes, Your Honor.
Let's move on. All right. Calling 2024 DCV 4936, Laura Lopez versus Hardy Hole Drilling. And all, may I have announcements, please?
Good morning, Judge Calmandel for plaintiff.
Randy Grambling for the defendant, Your Honor.
And scheduling status conference. You want the June 4th date?
Judge, that works. We're actually in mediation on this case right now with Mitch Moss.
Ooh, do you want to reschedule this for 30 days?
Well, if either way, if Dennis said will take the June date, that's fine.
Okay. Well, yeah, we'll do that. We'll do that and we'll get our scheduling order if we need it. Good luck. Okay.
Thank you.
You all know
Thank
the drill. Thank you. All right. Let's see. Mr. Nunez,
Yes, ma'am.
on 4775, we'll give them a minute to see if someone appears. If not, we're setting it for dismissal in 30 days. Did anybody respond to you?
His office answered, they were unable to find the case number, the case at all. So they said they're gonna have someone log on if they can, but they couldn't even find their client or anything.
Okay. So we took care of 4936. Who's
Yes,
next?
ma'am. So I'm on page 2, Judge, calling cause number 2024 DCV 3622, Cesar Sanchez et al. Versus Blanca Orcasitas et al. Announcements, please.
Good morning, Your Honor. Sebastian Uribe on behalf of the plaintiffs.
I'm sorry, was that you, Mr. Gonzalez?
Yes, Your Honor.
Okay, your audio is really bad. Could you please announce again?
Mario Gonzalez for the defendant.
Got it. Thank you. Okay. Good morning. Let's see. Yeah, I was gonna say, Mr. Gonzalez, I thought I remembered you were a recent sub-in on this case, and we are set for trial. Today's docket call. So what
Your
are
Honor,
you doing, gentlemen?
Your Honor, you had set this case for a status. Off the bench, you did grant the continuance. Agreed order for continuance was emailed to the court, first to Ms. Nieto and then
I do see that. I do see, hold on, because your audio is just not good. I do see that the status conference is set for April 8th.
Yes, I can jump in, Your Honor, if you need me to. Yes, as he said, he recently subbed in. We agreed to a continuance. It was granted during the last hearing. I believe the proposed order was never sent, but we did send it on the 23rd. So the court has it, and that's where we're at.
Okay, so do you all, I mean, are you in the middle of something where you want to just wait till the April 8th status, or you just assume get a trial date? Because we could take care of our status today since we're here, if we're looking at a trial.
Your Honor, I don't have full access to my calendar. Secretary's out right now, so I'd be kind of guessing.
At what?
At when my calendar is or is not already taken up. That's the only issue I have.
We're comfortable with setting it next year in June if that's okay. But
yeah, the trial date is going to be June 4th, 2027. And what I'll do is just with that, Mr. Gonzalez, if there's an issue that far down the road, let us know and we'll work with you on that. But I don't want to have you guys come in again on the 8th of April, unless you really want to, in which case, yeah, I'm happy to see you guys. But
I don't think that's necessary, Judge. And I did talk to Ansel about getting an order for mediation. I think this is the case that might be appropriate for that. I know he's not here now, but
let me stop you right there, Mr. Gonzalez. I can only hear about half of what you're saying. The order to mediate is part of the scheduling order. So please just circulate the scheduling order amongst you all with that June 4th date and return it. And I'm canceling the April 8th status conference, okay?
Thank you, Your Honor.
Thank you for your time. All right. Who's next?
Judge, on page 3, calling cause number 2025 DCV 1731 LVNV Funding LLC versus Drakaila James. Announcement, please.
Brianna Ojuku for the plaintiff, LVNV Funding, Your Honor.
Good morning. Give me 1 second. Our notice of hearing, that's good. Let's see. Have we had any contacts? And I'm sorry, Miss Ojuku, is it Ojuku?
Yes, Your Honor, thank you.
I don't see that I see the notice of hearing.
Mm-hmm.
I don't see the login information for the Zoom.
Okay.
Yeah. Have we had any contacts from Miss James?
No, Your Honor, we haven't. We haven't had any contact with her at all.
I'm gonna reset you one more time. I don't, you know, 30-day turnaround should give you enough time to and let me give you the date so we have it.
Okay,
we'll do April 22nd. No. We're gonna do April 29th.
Okay.
And same thing, 10 a.m. If you would just include the Zoom ID, and we'll be in and out hopefully in April.
Okay.
All right. Thanks so much.
Have a good day.
Have a good day. Who's next?
Judge, on page 3, calling cause number 2025 DCV 2036 Angeline Micaela Harpoon versus Transportadora Norte de Chihuahua S.A. de CV et al. Announcements, please.
Good morning, Your Honor.
Good morning, Your Honor. Pooja Tiwari for plaintiff.
And good morning, Your Honor. This is Andres Almanzan. I am counsel for defendant Transportadora Norte de Chihuahua, and I am special appearance counsel for co-defendant Jose Espinosa Monreal.
I thought, is that everyone? Hold on. Yes?
Yes,
I thought this was supposed to be set for something else.
I do, Your Honor. I think last time you were in trial and we had a short status during a break, and I think we were supposed to set a standalone hearing on the special appearance.
Yes.
And so, but I did see that today's notice was for a status.
Yes, we just got a reset, and I know since last time we were supposed to have that special appearance heard. What do you guys want to do? I cannot, if we're gonna look to set it and get a notice and nobody's, and you know, the way you're supposed to do it. It's not next week, but I can do the following week because I know this has been pending and we need to hear it. But if you want to argue it today and everybody's in agreement, I'm happy to hear it.
It's up to Your Honor. What dates did Your Honor have available in case we are going to have another date?
I would say April 8th, but let me pull the calendar up. April 8th. I know that is also a date I've been using to fill stuff up. No, there's nothing there. Okay.
Okay.
So I would say we would probably do 9 a.m. a little bit before the regular docket.
Okay.
So we're not in the middle of everything. Ms.
Yes.
Tiwari, how does that date work?
That works well for me, Your
My
Honor.
apologies for that. When I heard the style of the case, I knew immediately we were pending something and it's not set today. So we're going to do
Okay.
April 8th at 9 a.m. if you all are good with that. If something comes up and that doesn't work, let us know. We can, if you let us know quickly, we
Okay.
can set it quickly also.
And
Okay?
that's for 9 a.m., Your Honor?
Yes, sir.
Okay. Yes, we will be ready to have the special appearance heard at April 8th at 9 a.m.
Hearing on special appearance. I'm writing it down. Okay. Thank you. My apologies for
Okay.
that.
No
Thank
worries.
you.
Thank you, Your Honor. We
Have a good
appreciate
day.
it. Thank you.
Bye-bye. Who's next?
Judge, on page 3, calling cause number 2024 DCV 1322, Ricardo Betancourt versus Miguel Valles. Announcements, please.
Good morning, Your Honor. William Wallace on behalf of the defendant, Mr. Valles.
Hold on a second. Where is this? Have we had any contact from plaintiffs?
No,
Um,
Anyone?
none from us either, Your Honor.
Okay, let me just look at my list here. No one in the waiting room, Mr. Nanez?
No, ma'am.
Ms. Duran, did we have, was the notice, opened for today's hearing?
Yes, Judge, it was on the 23rd February.
Alrighty, and it's 10:22, was set at 10 o'clock. Dismissed. It's dismissed for failure to appear today. So thank you, Mr. Morales.
Thank you very much, Your Honor.
Have a good day.
I have one more case before you.
You
So
do?
thank you.
Okay.
Yes.
All right, Mr. Valenzuela, I think is next with Mr. I can't say it today. Go ahead and call it, Mr. Nunn.
Calling cause number 2025 DCV 2924, Imelda Soto et al. Versus Vista Hills Healthcare Center et al. Announcements, please.
Felix Valenzuela for the plaintiff, Your Honor.
Good morning, Your Honor. John Crawford and Craig Myers for the defendant.
And we are pending something, and that's why it's set for a status date. And I say something, but I know what that something is. I'm not saying something because I don't know what it is. But I know I have to look something up really quickly. So I'm just trying to buy some time. Give me a second. While I am looking things up, has there been any change in the status of this case? We are set for a status conference.
Your
I think
Honor,
we just-
there's no status in the case. I mean, the case is essentially done with. We're just awaiting your ruling on the two components of our motion, which is the dismissal with prejudice and the sanctions.
Yeah. So I did find my notes.
And that's where I guess we disagree because we believe the case is already closed, Judge. So the issue is just
Right,
sanctions.
the only thing was, yes, well, yeah, the fees, right? And so the amended motion to dismiss is respectfully denied. So do we need to have a subsequent hearing on the matter of the sanctions? Fees?
That's defense's motion, Judge, so I'd leave it up to them.
So
It's not, it is
I'm
not
sorry,
set
Judge.
today. So I can tell you, all right, Mr. Myers, are you here on this one?
Yes, Your Honor, I'm here with my partner, Mr. Krawcheck.
Okay.
And I didn't interrupt you. If I did, I apologize.
No,
The
that's
issue-
okay. It's just I had a notation, and we've just been a little bit swamped here. Was my intention in my email was to have an order for you before today, and that got overlooked. So
Got it.
I don't
Okay,
really
well,
like to do that just kind of here on Zoom. But go ahead.
No, I cut you off, and I apologize. If the court is going to provide an order on the dismissal with prejudice and the request for attorney's fees under Chapter 74, Section 351, we're more than happy to wait for that and reschedule if necessary. And we've already had a hearing on that issue, and I think we're awaiting the court's order. And Ms. Krawcheck, please tell me if I'm wrong on that front.
No, that's correct.
Okay. So yeah. So I just need to get you an order is what needs to happen. All righty. I didn't know if there was one. Did anyone provide any kind of proposed orders?
We did, Your Honor, but I'm happy to resend it to the court if it
See,
likes.
I felt like I had one, and that's what I'm not seeing in my emails. And so if you would resend it, please, so I can look at it. Yeah, I don't know why that got lost, but
Will do, Your Honor.
all righty. Thank you very much.
Thank you, Judge. May I be excused?
You may.
Thank
Have
you,
a good day.
Judge.
Thank you, gentlemen.
Judge.
Who's next?
Judge, top of page 4, calling
Wait
cause
a minute.
number.
Hold on a second. Hold on a second. I see Mr. Flores, and I want to go
Yes,
back.
Your Honor.
He's the attorney on the 4775.
Yes, Your Honor.
Yeah, so let's go back to that one real quick. This is 2025 DCV 4775. Jaime Nihans individually versus Evelyn Godinez and Juan Ramirez. May I have an
Yes,
out?
Your Honor. Yes, Your Honor. Rene Flores, in behalf of the plaintiffs, Gemini Hans. This is a hearing for status conference. We were able to serve one of the defendants, which is this situation we had pending, Juan Ramirez, last month on the 17th. So we're pending his response, his answers.
Okay.
That's the status we have right now. So fortunately, we were able to serve at least him. We're still pending
Working on
to
the other
serve Mr. Godinez.
Okay, so we're gonna reset you for 30 days scheduling status conference, okay?
Thank you, Your Honor. I
Thank you
appreciate
very
your
much.
time.
Yes, thank
May I be
you.
dismissed?
Yes, sir. Bye-bye.
Thank you. Have a good one.
Okay, so that'll take care of that one. So that'll be a 30-day scheduling status conference. Okay. Who's next?
Judge, top of page 4, calling cause number 2024 DCV 2837, Isis Gabriela Aguilar et al. Versus Julian Garland Contreras et al. Announcements, please.
Good morning, Your Honor. Manny Morga again for plaintiffs. Your Honor, this is a default
Got it.
judgment.
Yes, my apologies, Mr. Morga. I'm going back and writing other notes and had to catch up to your case. Yes, sir. Set for default.
Yes, Your Honor. Would you like for me to proceed?
Give me 1 second. All right, where is hold on one second. I think I'm just about to answer my own notice of default. Okay. So I need to make sure, because this notice also, Mr. Morga, I'm seeing the notice of default hearing that was sent out back on February 24th, which is absolutely, plenty of time. But it doesn't, it says in the 210th District Court of El Paso County, Texas. So I need to, since we're on Zoom, I don't always assume that people know that we're on Zoom. Mr. Nanias, will
I
you
see
go
what you're saying.
check outside and see if by some chance, who is it? Is it both? Oh, no, it's
No, it's just for
Julian
Julian.
Garland
That's
Contreras.
correct, Your Honor.
Can we go see if Contreras is out there? Frankly,
ma'am.
Mr. Morga, I think what I'm likely to do, and you can tell me if you have an issue with this, is likely going to be a reset of at least 3 weeks to get the notice that says that we're going to be on Zoom. I feel confident, I guess, that we didn't have any contacts, and I'll ask that, but I just want the notice to be accurate.
That's understood, Your Honor. I can inform the court, and if you want me to introduce it as an exhibit that's not attached to the motion, is we also sent Mr. Contreras via mail a notice of the hearing as well.
So yes, but does that notice have the Zoom information?
It does not, Your Honor, but I mean, if there's no one, if there's no one there, I can come to the courthouse right now if that makes you feel better, but I'll do whatever the court would like me to do, Your Honor.
Let me see if by some chance there's anyone out there. So the notice was mailed, just regular mail,
That's correct, Your Honor.
and it wasn't returned?
No, Your Honor.
Oh, okay. Mr. Nanias, nobody?
Judge, I went out to the lobby, called out 3 times for Julian Garland Contreras and received no answer.
All right. All right, Mr. Kennedy. Mr. Morga, go ahead. You may proceed.
He does have more hair than I do, Your Honor. Your Honor, would you like for me to introduce exhibits A through H that were filed in my motion for default judgment?
So you may introduce them. I'll tell you that for purposes of this hearing, the court will take judicial notice of all the documents in the clerk's file. So they're attached to your motion, yes?
That's correct, Your Honor. Exhibit A is the Texas crash report. B is our original petition. C is the return of service for Mr. Contreras. D is the photographs. E are the medical records for one of the minor plaintiffs. F is the second set of records for the second minor. And then G is the certificate of defendant's last known address, and H is the the certificate of defendant's military status.
Okay. So A through H attached to the motion are obviously also admitted for purposes of this hearing. Go ahead.
Thank you, Your Honor. This case involves a motor vehicle accident that occurred on March 27, 2024, when Mr. Contreras negligently hit my clients. We filed this lawsuit on June 12, 2024. Mr. Contreras was served on December 9th, 2024.
And how was that accomplished?
Your Honor, we served the Texas Transportation Commission pursuant to Civil Practice and Remedies Code 17.062, where a non-resident the Texas Transportation Commission acts as an agent for a non-resident. And so Mr. Contreras at the time of this accident is currently a non-resident of the state of Texas, but at the time of the accident, according to the case law and Civil Practice and Remedy Code, he availed himself to the jurisdiction of Texas courts since he caused a motor vehicle accident in the state of Texas on a Texas public highway. And so pursuant to that section, we serve the Department of Transportation or the Texas Transportation Commission. And they acted as an agent in this case, Your Honor.
Understood. Okay.
Your Honor, at this time, I mean, given that there's been no answer, I don't know if Your Honor would like testimony from the plaintiffs, since we are at this time we're not requesting liquidated damages, Your Honor. We're only asking that a default judgment be set as to negligence for Mr. Contreras for causing this motor vehicle accident.
Okay, bear with me because I am going through some of the exhibits. Do you have your clients or who?
We don't, Your Honor, simply because we aren't requesting liquidated damages. So pursuant to just our petition and the crash report that's exhibit A, we would move the court to grant a default judgment as to Mr. Contreras as to negligence in this cause.
Okay, what else do you have? Is that it, Mr. Morga?
That's it, Your Honor.
Okay, so obviously there's quite a few pages of exhibits attached to the motion. The court, if you don't have anything further, will take it under advisement at this time. If I need to come back, we'll set it, and then I will ask that you send out notice with the actual Zoom ID. But I want to make sure I go through everything that is contained in your motion before I rule. Okay.
That's understood, Your Honor. And if you want, we can get my clients to testify, and that might make it clearer as well for the court as far as the negligence of Mr. Contreras.
I think I just need to do a thorough review of what you have here, but surely if I have some concerns, I'll allow or continue the hearing to allow you to have that opportunity. Okay.
Okay, Your Honor. Thank you, Your
All
Honor.
right.
Appreciate your time.
Thank you. Who's next?
Judge, also on page 4 on cause number 2025 DCV 2724. That one's was set for an entry of judgment in 45 days.
2724. Okay.
Yes, ma'am.
Okay.
Okay, and going to the bottom of page 4, calling cause number 2025 DCV 2027 Claudia Garibay versus William E. West et al. Announcements, please.
Just to interrupt, Your Honor, I apologize for that. I should have been faster. On the last cause number 2724, I looked at the docket just right now. It says that the case is settled. I can attest that the claims against my client, because I represent Mr. Manuel Nunez, it's not settled, at least to those claims. I'm not sure about other claims for other co-defendants.
Yeah, let me go back to that case. Hold on. 27. Yeah, it's set for a scheduling it was set for a scheduling status conference today.
Correct, and that's why I'm here, Your Honor. We received that notice.
Go back and look at what's in here.
So if it could be a status / entry of judgment, I don't want to say that it's not settled for co-defendant. They're not. I don't think they're here today. So, but I know for our client, we're not settled.
So I'm sorry, your client is who?
Manuel Nunez. It's spelled on the document as Nunez, but his name is Nunez.
Okay.
And I know Miss De Leon, Felicia De Leon, represents Mr. Novato, a co-defendant in the case.
And they're the ones that settled. Is that right?
Perhaps. I have no knowledge of that.
Yeah, no, we need to set this for a scheduling status conference.
Okay.
Which it was set today, so I'm not sure exactly why it got canceled. So we'll see if we can get you in about 2 weeks.
Okay. Thank you, Your Honor.
That's April 8th, scheduling status conference. Okay. Thank you so much. My apologies for that.
And may I be dismissed?
You may. Thank you.
Have a good
All
day.
right. You too. All right. Now we can go to the next one.
Let me call again, Judge.
Mhm.
Calling cause number 2025 DCV 2027. Claudia Garibay versus William E. West. Announcements, please.
Good morning, Your Honor. Enrique Lopez on behalf of plaintiff Claudia Garibay.
Okay. So we're set for a dismissal, a status dismissal, and this is the second one. And then there's nothing other than my order setting hearing and the event. So what's happening?
Yes, Your Honor. This is a case of an adverse possession case. The owners of the property, the West, cannot be located. We are doing our due diligence in trying to locate them before we do publication, citation by publication. We were able to locate an address to a William West, and we're trying to verify if those addresses are good so that we can attempt service on Mr. William West. So in doing our due diligence, trying to locate these defendants, it seems like we may have found one of them.
You have 2 weeks. 2 weeks, and we're going to be set for a dismissal. I mean, it
Oh.
needs to move. It's been filed since May of 2025.
Okay, very well. Thank you.
Thank you. Bye-bye. Who's next?
Judge, on page 5, calling cause number 2025 DCV 4535, Jose Angel Barajas versus Manuel Romero III et al. Announcements, please.
Good morning, Your Honor. Ashley C. on behalf of the plaintiff.
Good morning, Your Honor. Servando Rivas on behalf of defendants Uber Technologies, Inc., Razier LLC, and Uber USA LLC.
Good morning, Judge Joshua Murphy on behalf of Manuel Romero.
Good morning, Your Honor. Tyler Slaughter on behalf of defendant Jesus Palacios.
Good morning, everyone. Bear with me 1 second, please. I don't know why I'm so slow on my note writing this morning. There we go. Alrighty, and we're set this morning on defendant's motion to compel arbitration. And the scheduling status conference is there too. So is that you, Mr. Rivas?
Yes, Your Honor.
Ready to proceed?
Yes, thank you. Well, this is, like you mentioned, this is a motion to compel arbitration filed by my client, Uber. A little bit of background for Uber. Uber is a technology company that provides a platform for drivers and riders to connect for transportation services. To gain access to the Uber platform before signing up as either as a rider or a driver, you have to agree to certain terms. The terms include an arbitration provision, which is the provision at issue before the court this morning, and the arbitration provision in this case was agreed to by the plaintiff on July 16th of 2023. The arbitration provision applies to personal injury claims. And this lawsuit arises out of an October 5th, 2023 car accident while the plaintiff, Mr. Barajas, was the passenger of defendant Palacios through the Uber application. At the time of that ride, defendant Palacios and the plaintiff were involved in a vehicular collision with co-defendant Romero. Therefore, the injuries alleged by the plaintiff arise through the use of the Uber application, and thus my client seeks to invoke the arbitration provision that the plaintiff agreed to. The Like mentioned before, Your Honor, the arbitration provision applies to personal injury claims that the plaintiff may claim. In this case, they are claimed. The arbitration agreement between my client and plaintiff stipulates that the Federal Arbitration Act governs the interpretation and enforcement of the dispute resolution procedures. Federal courts examining this same arbitration provision uh, have stated that the arbitration agreement within the scope of the FAA, which is the Federal Arbitration Act, shall be valid, irrevocable, and enforceable. The arbitration agreement also contains a delegation clause, Your Honor, and Texas courts and the Supreme Court of the United States, uh, and let me clarify, the Texas Supreme Court and the Supreme Court of the United States have validated delegation clauses, and this delegation clause states that, quote, only an arbitrator shall have exclusive authority to resolve any dispute arising out of or relating to the interpretation, applicability, enforceability, or formation of this arbitration agreement, including without limitation any claim that all or any part of this arbitration agreement is void or voidable, unquote. So despite the parties' agreements to arbitrate, Your Honor, and repeated correspondence sent to the plaintiff's counsel seeking her agreement to enter arbitration without the court's involvement, the lawsuit was filed and this motion was necessary, given I did not receive a response from plaintiff's counsel on my solicitations. And under governing Texas Supreme Court authority, Your Honor, a party seeking to compel arbitration under the FAA must establish, one, the existence of a valid enforceable arbitration agreement, and two, that the claims at issue fall within the arbitration agreement scope. Here, the parties have an agreement to arbitrate. The plaintiff agreed to the terms on July 16th of 2023, which was before the October 5th, 2023 alleged car accident. And the arbitration agreement, Your Honor, explicitly states that it applies to personal injury claims that the plaintiff may claim arising out of his use of the Uber application. That is the crux of my argument, Your Honor. I do want to point out lastly that plaintiff did not respond to Uber's motion to compel arbitration, and this honorable court's local rule 3.11e states that opposing parties' failure to present a response with supporting authorities may cause such arguments to not be considered by the court. Thank you, Your Honor.
Your Honor, may I respond?
And that's what I was looking for. I was looking for the response. I didn't see one.
Yes, Your Honor. I reviewed the arbitration clause. I've reviewed this motion. Due to this, because we were not aware of that until fully. We agree. We're asking then for the court to consider that if plaintiff with Uber Technologies Inc., Uber USA LLC, and Riser LLC, that just those parties be then ordered to arbitrate. We're asking that we be required to arbitrate with Judge Ancliffe, who is a member of the American Arbitration Association and is recognized, and that we're also asking that it only states that portion of the case for those parties and not the entire case for all other parties.
Do you have any input on that, Mr. Rivas?
Yes, Your Honor. Thank you very much. I agree with Ms. Cedillo that there is no dispute about the scope of the arbitration agreement in terms of this arbitration agreement was between Uber and the plaintiff. No other parties in this case are invoked, and in that regard, I am in agreement. In terms of agreeing to the proposed arbitrator, I'm sorry, I didn't catch his name. I wrote something down. I don't think I got his name correctly, but in terms of that, I would defer the court to the arbitration agreement. I'm not necessarily opposed to the appointment of this arbitrator. I'm just wanting to give deference to the arbitration agreement, which outlines that the parties, Ms. Cedillo and Uber, can agree to an arbitrator at some point after arbitration is ordered. It doesn't state that, for example, that the proposed arbitrator that Ms. Cedillo has proposed is going to be the arbitrator. It is a much broader arbitration agreement that considers the parties not negotiations, but discussions in appointing an arbitrator. And the arbitration would proceed through the American Arbitration Association is my understanding of the arbitration provision. So it may very well be that we agree to this arbitrator. I just don't want to confine myself to agreeing to that. And of course, Your Honor, I will defer to you in that regard.
All right, so Ms. Cedillo, the motion to compel, and Mr. Rivas, the motion to compel then is, it's granted, but almost by agreement. And I am not going to limit, I understand your request, and it might be, I think what I hear Mr. Rivas saying is the agreement is going to govern and the court is in agreement with that. And it may be that Judge Ancliffe, falls within those parameters. So what I will say with respect to that, I mean, I gotta think it also governs any disagreement about, well, no, I'm not gonna say disagreement, but the selection of the arbitrator. So the motion to compel is granted, and I think it's outlined what the scope of that arbitration is,
and
with respect to the parties.
And Your Honor, I could be mistaken, but, and maybe I missed it because our arbitration agreement is excessively long, but I don't see anything or how the parties are going to resolve in the event that they do not agree to an arbitrator.
Does the arbitration agreement address that?
I just see that the parties can confer about an agreement of an arbitrator, but I didn't really see about what's happened if the parties don't agree on an arbitrator. I do see arbitrators' decisions final. I see offers of judgment must be presented prior, things of that nature, but I didn't see about what to happen in the event the parties don't agree to a mutual arbitrator.
Mr. Rivas, do you have any input?
I could be wrong, and I apologize.
Yes, Your Honor. I just want to say, if Your Honor orders arbitration, we're going to arbitration. We're going to stand by this court's order. We're not going to nitpick any sort of argument to avoid arbitration. We will follow the terms of the agreement, and the enforceability of the arbitration agreement is under the scope of, I guess it would be a threshold question. To Ms. Cedillo's point, I could just reassure the court that we are here seeking the court's order, and we will follow the court's order. And I've been doing this for a bit, and I don't believe an issue will arise in terms of the agreement to an arbitrator.
Then, Your Honor, in that case, as part of granting of the motion to compel, can we also have an order that the parties, both for plaintiff and Uber Technologies, Inc., Uber USA, LLC, and Razor, LLC, will present and report to the court the arbitrator selected within 30 days from the order being entered?
I mean, we can do that, but if we hit a glitch there, I'm not sure that I'm going to hear that. Okay. I mean, I don't have a problem saying, hey, sure, let me know in 30 days. And,
and that's kind of
things, but at the end of the day, the arbitration agreement is going to govern that.
Yeah, and I don't remember the arbitration properly handling or mentioning disputes in regards to arbitrator, but just so then that way we can have something, because I saw that special masters could be appointed, but that's only more for class action suits, which the arbitration agreement does not allow. So that's why, it's a very lengthy arbitration. I've gone through it. And
Your Honor, if I may, can I add something, Your Honor?
Absolutely.
Well, in that regard, part of the prayer in the motion was that, which is consistent with the way the arbitrations proceed, that this case be stayed in state court. And we have requested that so that the proper channels can be pursued, which is the whole basis of this motion, arbitration.
And we're fine with that, Your Honor. It's just that it says for rules or governing laws, when I go through it, it primarily mentions for disputes arising in California, and this is not a dispute arising in California.
See, here's the thing, Ms. Cedillo, let me stop you. That's why, you should have responded. You should have filed a written response. The order is, I'm not going to go backwards and I'm not going to say nitpick because it makes it sound like it's not important, but I'm not going to go through all those details. The motion to compel arbitration is granted. I'm frankly not inclined to bring you back for anything. It's granted.
Okay.
Okay?
Mhm.
So, I mean, I don't want to seem like a negative. I think you all are gonna be okay, but maybe I'm jinxing it. And the matter is stayed until you all get that taken care of. Okay, normally on these, what I do is I do set a scheduling or a status conference 6 months down the road, just as a check-in, to see how things are proceeding. Okay, so.
And then for the remaining defendants, Your Honor?
Right, so we had a scheduling status conference today, and I was looking at some of these entries. I think there was something filed by you, Mr. Murphy, or the motion to enter a level 3 discovery control plan. Is that right?
That's correct, Judge.
Okay. How would you like to proceed? I mean, in light of the motion, how would you all like to proceed? I mean, I could set you, I could say get your scheduling order together and you know, we can have it back in 2 weeks, but what do you, in light of the status as we are right now, how would you like to proceed?
Well, the other parties are still in their written discovery stage.
Mm-hmm.
I know that we are working on discovery responses, hopefully to produce some responses this upcoming Friday. So the other parties are still in very early written discovery stage. We've exchanged initial disclosures. I believe we filed all of our affidavits. So
just a regular trial track, so June 2027?
That
yes,
that sounds well with me, Judge. I don't foresee an issue, but if there's issues that arise, we can come to the court and make the court aware well before that date.
Okay. Well, we'll do that then. We'll do June 2027. I think I just have some kind of a version for saying June 2027 because it's so far away.
Your Honor, can I ask you something real quick? I apologize.
Yes, sir.
On the DCO, would you like my client to be a signatory on it, or since this case is stayed, I believe I do not have to be a signatory. Is that correct?
No, this is just going to be circulated through Mr. Slaughter, Murphy, and Cedillo.
Thank you, Judge.
Mm-hmm. And then, yeah, somehow we're going to have to make a distinction. I know Ms. Nieto isn't here. Somehow we're going to have to give me a reminder because we're going to have dates, you know, our regular interim dates leading up to trial for me to ask and not forget about the arbitration. Okay?
Yeah.
I might forget. Maybe you guys won't let me forget. That'd be good. All right, what else?
I believe that's it, Your Honor, on this case.
Okay.
That's it for me, Judge.
Make sure you all agree to your mediator for the rest on your scheduling order, please. Okay?
Understood, Judge.
Thank you very much. All right, that was painless. All right. Who's
Thank
next?
you, Your Honor. Have a good day.
Take care.
Thank you, Your
Take
Honor.
care.
Likewise. Bye-bye.
Okay. Who's next?
Judge, bottom of page 5, calling cause number 2025 DCV 4699. Abelardo Garza Hernandez versus Jesus Rodriguez de la Cruz. Announcements, please.
Good morning, Your Honor. Sebastian Uribe on behalf of the plaintiff.
All righty, we are set for default. Give me 1 second, Mr. Uribe.
Not a problem, Your Honor.
Anyone here on behalf of Jesus Rodriguez de la Cruz? Anyone in the waiting room?
No, ma'am.
All right, the motion was filed February 19th.
Hello?
Let me mute Mr.
Yes, ma'am.
Okay, did I mute him? Yes.
Yes, Your Honor. The petition was filed back in October 16 of 2025. Answer should have been filed in November 24 of 2025. We haven't gotten any an answer to the original petition or to the motion for default judgment. We sent a notice of hearing to the plaintiff, and he didn't appear today either.
So let me look at the notice real quick. I do have your motion here with the attachment, the order setting hearing. What is this? Bear with me. Let me just go through some of these. Okay, no, the notice did have the Zoom ID. Who is this? Okay, so this individual was served back in November.
October 29 of
October
2025.
29th, pardon, at 3:41.
Yes, Your Honor.
And this individual was in custody, is in custody?
Yes, Your Honor.
Is he still in custody? Do you know?
Yes, Your Honor.
All right, go ahead, Mr. Uribe.
Your Honor, at this time, the plaintiff moves the court to, or respectfully moves the court for a default judgment. And the default judgment was sent to the court this morning. In it, you will see that we're requesting actual damages in the amount of 402,500, pre-judgment interest, attorney's fees, court costs, and post-judgment interest.
Okay, bear with me. Okay, so I need to review some things on this, Mr. Uribe. If you've provided the proposed judgment, that's fine. I do see the motion. But I'm going to review it, take it under advisement, and I will let you know if we need to come back. Okay?
Of course, Your Honor.
Thank you very much.
Thank you. May I be excused?
Okay.
Thank you.
Okay. All right, who's next?
Judge, on page 6, our last case today, calling cause number 2025 DCV 0054, Brianna Araceli Jaime et al. Versus Trans America Protection Corporation et al. Announcements, please.
Orlando Rodriguez for the plaintiffs.
Good morning, Your Honor. Fred Hutterer for defendant Michelle Marie Maltos.
Good morning. We are set on the motion for summary judgment. I feel like I had some emails though, and just my brain is full right now. So what were the emails about?
Not an issue, Your Honor, if I may. Defendant Maltos filed motions for partial summary judgment on gross negligence and IIED claims. We did that mainly to preserve a deadline. The current deadline to have that heard is April 12th or 13th, I believe. Ms. Rodriguez filed a motion for a continuance of this hearing. I am in complete agreement with that. I just filed those motions to comply with the deadline. Written discovery is largely complete. I understand plaintiff has a motion to compel pending against defendant Transamerica. I also understand that they are working to resolve that issue. Other than that, we need party depositions, and I believe that a mediation will be productive on this one. And so we're continuing to work this one up, Judge. And we have all been active in this case. I anticipate that in an effort to resolve the deadline issue, the parties will file an agreed motion for continuance, which would be the first continuance of this matter, to allow us to finish discovery and get this case mediated. I expect this one should be relatively simple to resolve. And so that's where we are, Your Honor.
Right, but with respect to the summary judgment, let me see, when was it filed? I mean, unless that's, I understand you have to meet a deadline, but then I also have to meet a deadline, which is, but isn't it 90 days from filing? I'll have to go back and look at my notes.
I believe it's 90 days, Your Honor. This would be the first one we filed since the rule changed. However, I would be happy to put together or incorporate some language in the motion for continuance that would address that issue as well. We could withdraw that motion and resubmit it.
Well, see, that's where that's what I've been asking, because obviously, everybody's working with these new timetables and filing motions, and then, you all work on things, and the court is still under an obligation to have a ruling. And so I've been asking, if you don't want me to rule, then you need to withdraw it. But I don't know how that plays into your deadlines and timetables. So
Assuming assuming we can get that agreed motion on file, Judge, and assuming the court grants it, then that doesn't really affect my deadlines at all. We would just withdraw the motion and resubmit it at a later time after discovery has been more substantially completed.
Okay, so I am going to reset. I think it's still, yeah. I'm going to reset today's hearing. What I'm hearing, and Ms. Rodriguez, chime in if any of this is not okay with you, is to reset today's hearing to the motion to compel hearing date as well. So you're going to see a setting for the motion for summary judgment and the motion to compel on April 29th as set. Okay, we're passing it today. And between that time, if I get a motion to withdraw your summary judgment, great, and it'll go away. Okay.
Understood, Your Honor. And we'll probably lump that in with the motion for continuance as well, just so it's in one document. We
So
address
what are
both
you
issues.
asking, Mr. Hutter, what are you asking to continue?
The trial date, Your Honor, which would resolve that summary judgment hearing deadline.
I
So,
see
Your Honor,
and I think it's next year, but that's this year. Sorry. Go ahead, Ms. Rodriguez.
yes, Your Honor, thank you. So we had agreed to continue the hearing for today, or at least for that. We did file a response, but we did also file that continuation of proceedings for today. I had spoke to Mr. Hutter, yes, as well, that we are in agreement to discuss that next week about continuing trial date. But of course, we are still pending this hearing for the motion to compel. So we're in agreement with this court to reset the hearing if we can to the motion compelled. I think that we can get it resolved till then. Our issues as far as these documents that need to be that are being filed. So yes, we're in agreement as well.
Okay, so that, I guess, the motion for continuance is granted. It is reset for April 29th. Over all of these things will be a status for April 29th, and we'll just check in with you all and see where we are and if we're getting our new trial date, all of those things. Okay.
Understood, Your Honor.
Thank you for your time. Appreciate you all.
Thank you.
Who's left? I see.
That's everything, Judge. The last one on page 6 was canceled. The 4833.
Okay, so who's left here? Who's?
We've got Miss Apai here.
Yes. Good afternoon, Your Honor. My name is Rhoda Piabuate. I'm here on a case. It may be off your docket. This is Wells Fargo versus Lucia Vasquez, ending in 4833. It was set for a motion for summary judgment, but I know the parties have settled. So perhaps it wasn't.
It does show canceled in Odyssey, Judge.
Okay.
I'm sorry, what?
It does show canceled in Odyssey.
It shows canceled?
Yes, ma'am.
Judge, there is an order withdrawing the summary judgment.
Yeah, because the parties have settled.
Okay, so we set it for an entry of judgment in 30 days, okay?
All right,
Thanks so much for appearing. Bye-bye.
Thank you. Bye-bye.